Hi, my name is Andreas Glarner. I'm partner at MME's Crypto Team here in Switzerland. As you all know, FINMA gave some guidance how to do ICOs in Switzerland. I would like to give you an overview on FINMA's assessment and starting with the token qualifications FINMA made. FINMA principally distinguishes between three types of token. First of all, we have the payment token. Payment token is what FINMA considers as a cryptocurrency, so there's no counterparty involved. It gives no right towards any counterparty. Bitcoin would be an example of that. Second category are utility tokens. Utility tokens give access to a protocol or a decentralized application. And the final category are asset token. Asset token do have a counterparty and give a right to a revenue stream, a share of a cash flow, or a similar right. As I said, the approach of FINMA in the categorization is rather result-driven. So each of those categories may be linked to a certain set of regulations. Payment token, the main focus is that AML regulations may apply. With regard to utility tokens, basically no regulations apply. And with regard to asset token, in principle, they could qualify as uncertificated securities under Swiss law. But don't be too concerned. This Swiss regulation on uncertificated securities does not regulate the issuing market, the primary market, but is focusing only on the secondary market. Now, what FINMA also does, it distinguishes between four different kinds of development stages. The first stage will be the pre-financing stage. Thus, there is where a project owner receives funds to develop the project in a very early stage, based on a soft agreement, based on an early contribution agreement, but does not give out any token at all. The second development stage will be the pre-sale, also voucher as FINMA calls it, where a token is being issued and allocated, but this is not the final token. It will need to be converted in the later stage into the final token. Normally we see that in protocol developments where the protocol on which a final token will run needs yet to be developed. The next development stage is the pre-operational token, where we have already a fully functional token, but the application is missing on which it can be used on or which it shall be used on. So normally we see that in the ERC20 token launches where the application yet needs to be developed. Then the final stage is the operational token phase. And now what we can do is an exercise to allocate those different development stages to the different token models and the regulations. We start with the payment token. So what comes out very clearly from the FINMA guidance that they consider that the issuance as part of an ICO of an operational or a pre-operational payment token would be subject to AML regulations. FINMA makes no comments on the pre-financing and pre-sale part, but in our assessment, they're quite far from being a mean of payment. Thus, AML regulations, in our point of view, do not apply. With regard to utility tokens, as I said, principally no regulations apply. Also, no regulations for the pre-financing, no regulations for the operational token. We leave that here in the middle here for the time being because there's some ambiguity. Asset token, with regard to security regulations, FINMA's approach is that on the issuance of operational asset token, of pre-operational asset tokens, as well as the voucher tokens, security regulations may apply. They may not apply where there's no token around. Thus, the whole pre-financing is being cleared. Finally, with regard to utility token, here we have some uncertainty because FINMA indicates that under particular circumstances, a utility token in a voucher phase or in a pre-operational phase may also qualify as an asset token. Thus, this area here needs to be assessed very carefully. Also important to note is that the qualifications being result-driven allows hybrid token models, meaning that you could qualify as a payment token and as a utility token in the meantime, or the same applies to other categories and the mix of that. Yes, this was an overview, FINMA guidance in a nutshell. I hope it was helpful and educational. Please note this is no legal advice. If you aim at launching a token generating event in Switzerland, I strongly recommend to get profound legal and regulatory assessment first. Thank you for listening.